And good morning. Good morning, everybody, and welcome to today's webinar on the recent Fair Work Act changes. And not only the changes, but how they'll impact on your business as employers. My name is Michael Jones, and I'll be your host today. I would like to take this opportunity to acknowledge the traditional owners of the lands on which we, are webinaring today, and their elders past, present and emerging. All right, so now on to the topic of today. It's interesting, we live in a time of significant changes, but I think nothing has changed more in the last 2 years than the nature of work and the management of the workplace. I'm talking about social changes, but there's also been legislative changes, and it's the legislative changes that we'll be going through today, because it can be very difficult and demanding being an employer, and guess what? It's not getting any easier. So there were new amendments to the Fair Work Act 2009, and they were passed in late 2022, so just at the end of last year. Employers are now faced with changes that will impact how they manage their workforce. So today, we have the Mazars HR and IR specialist, Cheryl Ann Laird, who will step us through what these key changes are and identify what employers need to do to be prepared so that they can properly manage their workforce. Cheryl Ann is a very experienced advisor on employment matters, and I know clients have been very grateful for Cheryl Ann's guidance through various and difficult employment issues. So therefore, I'm really pleased that Cheryl Ann's going to take us through these changes today. So let's get started, Cheryl Ann. I'm sending it through to you.
Great. Thank you very much for that lovely introduction, Michael. We have a lot of information to cover today, so for those of you out there on the webinar, please bear with us. Of course, I'm not going to be able to cover all of the upcoming changes, but we've selected those that the feedback from our clients have indicated are those with the most relevance to their day-to-day operations. But if we don't cover something of importance to you, as Michael has said, please put your question in a chat and we will get to it either at the end, during, or even after the webinar. So let's get started. There are some dates which are relevant in terms of these changes. So they didn't want to make it easy for employers. They've implemented things at different dates. There were some things that came in on the legislation being passed back in December of 2022, and then progressively through 2023 we'll see some changes taking effect, the dates being the 6th of March, the 6th of June and then the 7th of December. So let's get started with some of those changes that have been made. So let's look at the first one, which was one of the changes which came into play from the date of the legislation being passed. So it's from the 6th of December 2022. So pay secrecy. Ooh, sounds interesting. This is a change which is intended to assist in resolving the pay equity issues. For some reason, there's a belief that people not talking about what their salaries might be somehow facilitates an ongoing pay equity issue. The provision in practice is actually quite simple, and what it requires employers to do is not include pay secrecy provisions in an employment agreement, not tell their staff that they must keep their pay a secret, and more importantly, not take any action against an employee who elects to disclose or not disclose their pay to another person. When we're talking about pay in terms of the pay equity, in terms of the pay secrecy, it extends to salary and wages, as well as other terms and conditions of the employee's employment that are reasonably necessary to determine their remuneration outcomes. So it includes things like the number of hours that an employee might work. So that too can no longer be required to be kept secret. In essence, employees can ask others about their pay and remuneration both within their own business and within other businesses. And your employees may, at their own discretion, elect to disclose that information or not disclose it. If you are an employer who already has pay secrecy provisions in your employment agreements, you are not required to reissue those contracts. However, that part of the contract, the provision which requires pay secrecy, will be unenforceable. So you don't have to get new ones, but don't think you can rely on those provisions which are already in some contracts.
Actually,
yes, Michael.
I have got an early question, which maybe we'll just ask it now on the topic of pay secrecy. And it's Jacinta who's asked, what happens if I don't include pay secrecy requirements like in my employees' contracts, but I tell my senior executives it's my preference that they do not disclose their pay details? What happens then?
Oh, that's a tricky, cheeky question, Jacinta. The answer is, until we see the case law, we're not going to be able to be completely sure how far the legislation will go. However, my advice is don't do it, particularly if the employee believes that your preference for them not disclosing it might have consequences for them if they do disclose it. And the reason for that's a great question, Michael, because it lets me lead straight into the next bit, which is, well, what happens if you do continue in this practice? So not being required to maintain pay secrecy is being considered a workplace right. So a breach of this provision will be a general protections issue and will therefore raise the risk of the imposition of a civil remedy provision. Contravention of the prohibition on pay secrecy terms attracts a civil penalty for serious contraventions of up to 500 penalty units, or otherwise up to 60 penalty units for an individual and 5 times that for a body corporate. Might be interesting to know, a penalty unit currently is $275. I'm not going to do the math for you, but you can assume they're big numbers if you do not stop telling your employees they need to keep their salaries a secret, or as per the question, even inferring that perhaps it's your preference or a good idea not to do so. Okay, so pay secrecy sounded like a big issue. It's really quite small, really quite straightforward. So we might move on to sexual harassment. We've got the slide up. Prohibition on sexual harassment. An employer's responsibility to provide a safe workplace hasn't changed. However, the level of accountability for sexual harassment in connection with work has changed. From the 6th of March, there is an increased risk for employers arising from any sexual harassment which might occur in their workplace. These provisions seek to implement the recommendations from the Respect at Work report. So what is sexual harassment for the purposes of the Fair Work Act? The Fair Work Act has adopted the definition of sexual harassment from the Sex Discrimination Act 1984, which is also a piece of federal legislation. In accordance with that legislation, sexual harassment is an unwelcome sexual advance or request for sexual favours to the person who is harassed, other unwelcome conduct of a sexual nature in relation to the person who is harassed. Conduct of a sexual nature has been defined by the case law quite broadly. So it doesn't have to be specifically related to a sex act. It can be anything that a person might feel uncomfortable or offended or intimidated by. To that end, to be sexual harassment, it has to be that a reasonable person would expect that there is a possibility, so it's not a very high bar, that the person being harassed would be offended, humiliated or intimidated by the behaviour. This This means that whether behaviour is sexual harassment depends on how a reasonable person would interpret the behaviour in that situation, not necessarily how the individuals actually in the situation might interpret it. Behaviour that is sexual harassment, therefore, in one set of circumstances may well not be considered to be sexual harassment in another set of circumstances. Importantly, and this is one that we find employees very much struggle with, is when you're working out whether a certain conduct is sexual harassment, the intention of the alleged harasser does not matter. I know we often hear when getting involved helping employers with these matters, the person saying, but that's not what I intended. If a reasonable person observing those circumstances believes that a person might have been, there was a possibility that the person could be offended, humiliated or intimidated by the behaviour, the intention doesn't matter. Sexual harassment doesn't have to be repeated or continuous, so it is different to workplace bullying. It can be a one-off incident. Sexual harassment in the course of employment can be considered serious misconduct and can be a valid reason for dismissal. The Fair Work Act was amended last year to include sexual harassment on the list of serious misconduct that could justify termination of employment. Importantly, the prohibition would include sexual harassment perpetrated by third parties, such as customers or clients, for example. Sexual harassment of third parties by workplace participants, for example, by one of your workers against a customer, is prohibited under the Sex Discrimination Act, but it is not picked up under this definition of the Fair Work Act. It would in fact still be enforceable via compliance frameworks that applies to contraventions of that Act. There may also be state legislation about what happens if one of your employees is engaged in sexual harassment of a customer or a visitor to your workplace. Of course, it would still be very much a workplace disciplinary issue, as I'm sure none of the employers out there would think that engaging in such conduct in relation to your customers or clients was a good plan. These new provisions in the Fair Work Act replace the existing Stop Sexual Harassment Orders, which was the current jurisdiction until the 6th of March of the Fair Work Commission. However, the new jurisdiction, although broader, still has capacity for the Fair Work Commission to make such orders. However, it may well be that those powers are expanded in that the previous jurisdiction was limited to sexual harassment at work, whereas the new jurisdiction refers to sexual harassment in connection with work. So what is the scope of these provisions? It's a worker in a business or undertaking, a person seeking to become a worker in a particular business or undertaking. So it's even broader than the sex discrimination legislation, in that it's people who are looking to work in your organisation. And a person conducting a business or undertaking, so it covers all of us who are business owners and senior execs. The meaning of worker is the same as that under the workplace health and safety legislation, which extends it to not just employees, but also contractors, volunteers, subcontractors, an outworker, an apprentice, a training person or a student doing work experience. So the definition of who might be a worker and who might therefore be your responsibility to prohibit them engaging in sexual harassment is quite broad. The other significant change is to the issue of vicarious liability. Now, employers have always run the risk of vicarious liability in relation to sexual harassment in the workplace. However, the Act has now defined it in such a way that, in my view, the risk has increased, in that vicarious liability will arise where the principal, that's the employer usually, the business owner, can not prove, so it's a bit of a reverse onus here, that they have taken all reasonable steps to prevent the employee or agent from doing acts that would be considered to be sexual harassment. So it's all reasonable steps, not just those which you thought were okay, would get me across the line. It is all reasonable steps. Once we get some case law, we'll start to get some better understanding of what is going to be considered all the reasonable steps that an employer might be able to take. The other change in the Fair Work Act in this space is the Fair Work's jurisdiction to actually become involved in seeking to resolve disputes about sexual harassment in the workplace. Employees who believe that they may have been sexually harassed may make an application to the Fair Work Commission. Unlike the prior Stop Sexual Harassment jurisdiction, where the Commission could only issue orders to stop future harassment, the new jurisdiction allows the Fair Work Commission to make orders directed to remedying past harm caused by sexual harassment, including monetary compensation. The types of orders might be compensation, payment in relation to lost remuneration if someone has taken time off, or the Commission may direct the employer or another party to carry out a course of conduct to redress loss or damage suffered by the aggrieved person. The Fair Work Commission may also express an opinion about if the applicant has been sexually harassed or if there has been a breach of the vicarious liability provisions of the Act. Importantly, the Fair Work Commission's initial jurisdiction does not include arbitration for sexual harassment disputes. However, once the Commission is of the view that all reasonable attempts to resolve the dispute have been exhausted, they must then issue a certificate to that effect. The parties may then agree with the Fair Work Commission proceeding to arbitration, or an applicant can use the certificate that's been issued by the Fair Work Commission to make an application to a court. From a practical perspective, it will very much depend on a circumstances by circumstances matter as to whether an employer is better off agreeing to arbitration in the Fair Work Commission or waiting to see if the applicant makes an application to the court. Of course, as a sort of general view, applications in the court are much more expensive for all parties than matters which are resolved by the Fair Work Commission. Contraventions of this piece of the new legislation are also considered to be a civil remedy provision with up to 60 penalty units for an individual and 300 penalty units for a body corporate. Keep in mind those penalty units are quite separate to any sort of compensation or reparation, which may be ordered in relation to the actual damage done by the sexual harassment. So on this one, what should employers be thinking about now? What do you do? What can you possibly do to ensure that you have done all things reasonable to prevent sexual harassment in your workplace? Certainly, as an absolute minimum, I would be saying to clients, make sure you have an updated sexual harassment in the workplace policy or in connection with work policy. Make sure that it reflects the new changes to the federal legislation. Make sure you have trained your people about what is sexual harassment and trained your managers as well about how to identify perhaps the warning signs that it may be occurring in your workplace and how to confidently intervene to prevent anything from escalating. You will, of course, also need a strong complaints process, which provides an avenue for employees to raise concerns as early as possible. The earlier you can intervene in what might develop into sexual harassment, the more likely it is you may be considered to have, in fact, done all things which are reasonable. So that's a bit of a sort of skip across the top of the new sexual harassment arrangements. I know this one is of great concern to a lot of employers because what we need to do all things reasonable isn't yet clear. But it's a good start to be looking at those policies, looking at your training, looking at your mechanisms for people reporting any concerns that they might have.
Cheryl Ann?
Yes, Michael.
I've got a couple of questions on this topic because it's, of course, such an important one and something that employers need to be so clear about. The first one is from Amanda, and it says, how often should we be training our employees on our sexual harassment policy?
Thanks, Michael. There is no statutory requirement in terms of timing or even running training, but failing to run training is going to in my view, very much mean you're going to not be able to demonstrate you've done anything, let alone all the things required. I would suggest that training should be refreshed at least annually. That assumes it's covered competently in your induction process as well, so that you're not getting employees who might have been with you for more than 12 months who've not received any training. So my advice would be make sure it's covered in your induction program, and then make sure it's covered in terms of your training at least annually. More often if you've got significant turnover of staff.
And look, I've just got a second one we'll put in because it's such a top topic. It's from Alison. Thank you, Alison. And the question is, do you have a policy we could use as a guideline to introduce to our workplace? But I guess I might just jump in here, Cheryl Ann, because it's in early May, we will be doing another webinar going deeper into this area, along with workplace bullying and that whole group of changes. And I mean, that's where we can probably address that, and stay tuned for more information on that. But is there anything particular you'd like to say, Cheryl Ann, on that request for a policy?
Only that I agree with you, Michael, that the next step is to sign up for our webinar in May on this topic in particular, where we will go into more detail on this. But if your urge is to move faster than that, certainly make contact with your normal Mazars contact, who will be able to put you in contact with the right person within the Mazars HR space, who can assist you with that. We're in a couple of states, so it might be me, or it might be one of my colleagues in another state. Okay, so next slide, please. All right, let's move on to flexible work requests, because I know this is another one that clients have been giving us feedback about, that they find a bit concerning. There seems to be a bit of a concern that suddenly the world has changed and employees are in charge of flexibility at the workplace. That's not quite what's happening. There are two types of flexibility requests that can be made: those that are made under the Act and those that are made outside of the Act. Okay, so let's talk about flexible work requests, which are those that are made under the auspices of the Act. These can only be made by a certain type of employee. Okay, it is not open to everybody to make a request under the Act. Who can make a request under the Act? It's parents or people with responsibility for the care of a child, if that child is school age or younger. Okay, or if the person is a carer. Carers are defined for this purpose as people who provide personal care, support and assistance to another individual in need of support due to disability, medical condition, including terminal or chronic illness, mental illness, or is frail and aged. The person making the application has a disability. The person making the application is 55 years or older. And these are some new ones that have been introduced as part of this process. The person making the application is experiencing violence from a member of their family, or the person making the application provides care or support to a member of their immediate family or household who requires care or support because they are experiencing violence from their family. And in each case, the person who's making the application can only do so if they've got 12 months or more of continuous service with the employer prior to making the flexibility request. These requests do have a pretty stringent process that's provided under the Act. So requests for flexibility under the Act need to be made in writing, and they need to set out the detail of the change that is sought and the reasons for the change. Employers are required to work collaboratively with the employee to identify if the request is not able to be accommodated and if there are other arrangements which might be able to be approved even if these were not part of the arrangements that were initially requested. This is one of the kind of major changes that we're seeing, is that the Act is actually requiring a much higher level of collaboration between the employer and the employee, and to explore all options, not just to look at what the employee wanted and say yes, no, but to say, well, if that's what the employee wants and I can't do it, what could I do for the employee to try to meet their needs? Because we'll know what their needs are, because they will have told us in the written request what they want and why they want it. Employers have 21 days from when they receive the written request to provide a written response. So all of those collaborative and consultation steps must be completed within the 21 days to allow the employer to provide that written response. Employers can only refuse a written request on reasonable business grounds. So it's not that employees are driving the agenda. If you have genuine, reasonable business grounds, you can say no. If the request is not able to be approved and there are no other options that you've been able to reach agreement on, you need to document that in the written response, including the options that you identified and said to the employee, hey, how about these things, as possible alternatives. You need to put all of that in the written response, even if they weren't accepted. So what are reasonable business grounds? So as things go along, we will get more detail as we get some case law in this space. But the examples that are provided in the legislation, so we can pretty much rely on them, are the working arrangements requested would be too costly for the employer. There is no capacity to change the working arrangements of the other employees to accommodate the requested working arrangements. It would be impractical to change the working arrangements of other employees or recruit new employees to accommodate the requested arrangements. The requested arrangements are likely to result in significant loss of efficiency or productivity, and the requested arrangements would be likely to have a significantly negative impact on customer service. So, for example, a fairly obvious one, if you're in the retail or hospitality sector and an employee was seeking to change their hours such that they were no longer available when your customers were seeking service, that would not be a practical change that you would be able to accommodate, and you would have reasonable business grounds on which to refuse that request. The list I read out a moment ago, it's not exhaustive, and it will change between each employer, including the nature of the work being done and the size of the enterprise. Of course, the larger your organisation, the more difficult it will be to prove reasonable business grounds, just simply because you will be seen to have greater capacity to accommodate alternative arrangements and flexible arrangements. But that doesn't mean that just because you're a large employer, you must give in to every request. It will be a genuine assessment about reasonable business grounds. The other change is that from the 6th of June, so this one isn't with us yet, it's looming, where an employee is dissatisfied with the response of the employer to their flexible work request, and remember, we're only talking about those who can legitimately make a request under the Act, they may make an application to the Fair Work Commission to have the dispute dealt with by the Commission. This is new. There have been some cases that have been able to proceed under grievance procedures under awards and agreements, but there has been no general jurisdiction for employees to pursue concerns around flexibility requests. The request to the Commission, or the application to the Commission, can also be made if an employer doesn't meet the 21-day timeline. The Commission can make any number of orders, and again, once we start to see some case law, we'll get a better understanding of how the Commission intends to deal with these. But they certainly would be able to say whether or not the refusal was on reasonable business grounds. As noticed earlier, though, an employee can also still make an application for flexibility with an employer outside of the provisions of the Flexible Work Request in the Fair Work Act. In such cases, employers ought to give those reasonable consideration. However, the difference is that if an employee is unhappy with the outcome of that application, they do not have the benefit of being able to take such a complaint to the Fair Work Commission. Keeping in mind, though, some awards and agreements already give people that capacity to take their grievance to the Fair Work Commission, even where it is about flexibility. So flexibility is not as bad as I think that it might have been painted to be in the media. There are limitations, and where there are genuine business grounds, you're not required to accede to those, but you are required to work collaboratively and consultatively with employees to see if you can come up with some arrangement that meets the needs of both the employer and the employee. So, Michael, any questions on this one?
I have. You must have been reading my mind. I've got a question here from Richard in relation to these flexible work requests. And he says, if someone who does not fit into the list of employees who can make a flexible work request under the Fair Work Act, and they make a request for flexibility, can it then be declined for reasons other than reasonable business grounds?
Yes, is the simple answer. Thanks for the tricky question, though, Richard. It can be. My advice to all employers, though, is if you are able to accommodate flexibility, it's a great idea, particularly in a tight labour market. But applications which are made outside of the auspices of the Fair Work Act don't have those same requirements. So you don't have the 21-day timeline, and you don't have to demonstrate reasonable business grounds to decline it. But just from a cultural perspective in terms of dealing with your own employees, if you are going to be declining flexible work requests, I would certainly suggest that it would be a really good idea to make sure you give them a reason. Otherwise, you're just going to have an inflexible, albeit disgruntled employee, which is not a great idea. Okay, so let's move on to the next slide, please. All right, so enterprise bargaining. Now, there are some changes coming in on the 6th of June. There are lots of changes for enterprise bargaining. This is one of those areas where it's impossible to cover the field in today's presentation. I'm going to tick off those things that most of our clients have said, oh, I wouldn't mind knowing a bit about this about, but please put in the chat if you'd like some more information. It is one of those things that we're thinking about running a webinar just on this because it is so big. But let's look at what we've got. So many of the changes are procedural, and we're still waiting on guidance from the Fair Work Commission on how they intend to process those changes in practice. So we're expecting new forms, we're expecting new information from the Commission about what they want us to do when processing things under these new procedures. Although most of the changes commence from the 6th of June, if there isn't a proclamation to commence them earlier, which given we're in March now, I don't think it's going to happen. There was a change to the process for commencing bargaining, which commenced in December 2022. This one may have some impacts for those of you who are already involved in the enterprise bargaining process. The Act has been amended to supposedly make it easier for bargaining parties to commence bargaining without the need for the level of formality which previously applied. However, it has limited application. It only applies for a single enterprise agreement, which the vast majority of enterprise agreements are single enterprise bargaining agreements, which has a nominal expiry date. So you've gone past the nominal expiry date, and that expiry date was in the last 5 years. And the scope of the agreement or potential agreement hasn't substantially changed from what might already exist. Okay, so you've got to have already been involved in enterprise bargaining. You've got to have an agreement that's past the nominal expiry date, and it can't be more than 5 years past, and your group of people to be covered by any proposed agreement needs to be the same. In such cases, a bargaining representative can actually just simply write to the employer and tell them they want to commence bargaining, and once they do that, the employer must then commence the process of sending out the notice of representation rights. So at the moment, most people start bargaining by sending out the notice of rep rights. This is just another way that it can be commenced. Where I think we're going to see it, and we've got one example already where this has been used, is where perhaps an employer has an old agreement and they've not been particularly keen to enter into new agreements. And because it had to start with the notice of representation rights being sent out by the employer, and there was no capacity to force the employer to do that other than going to the Fair Work Commission, I think this is a means to get employers a little bit more enthused about doing enterprise bargaining and bring them to the table without the need to go to the Fair Work Commission. There has been at least one case already in the mining industry where these provisions have already been used to bring what might be considered a reluctant employer to the table to commence bargaining for a replacement agreement. One of the other changes that's been discussed is the Better Off Overall test. It's intended that the Fair Work Commission apply this in a more holistic way as opposed to the current line-by-line assessment. However, how this is going to translate into actual practice is not yet known and probably will not become clear until after we start to see some case law after the June 6th. Because the current legislation requires that the Better Off Overall test be applied globally. It's just been as a matter of practice over many years that it has become a more line-by-line assessment. So there are going to need to be not so much statutory changes, but process changes in how these agreements are assessed. So it's a bit of a wait and see what the changes will actually be in this space. One of the other ones in terms of enterprise bargaining that's attracted a lot of attention in the media is multi-employer agreements. There are three streams for multi-employer agreements. The cooperative stream, where employers opt in to bigger pay deals, so they opt in to get together with people of like mind or in the same industry and do an enterprise bargaining agreement. The supported stream for low-paid workers, that's a stream that we already really have. It's just a different name for it. The new one is the single interest stream. The single interest stream would allow the Fair Work Commission to authorise workers with sufficient common interests to bargain together when it is in the public interest for them to do so. The Commission will consider common interests like geographical location, whether the businesses have the same regulatory regime, the nature of the business and their terms and conditions of work. The single interest stream requires the majority of employees at each employer to agree to take part in a multi-employer pay deal. There is a small business exemption to reduce the potential pressure on small businesses such as cafes, independent stores and other local enterprises. Small businesses will be exempt from the single interest stream. A definition of a small business is a business with fewer than 20 employees. So it's a different definition than is used for small business in terms of redundancy and minimum employment period, which is 15. Here, a small business is 20 employees for this purpose. And it means that a small business cannot be included in an application without their consent, even where more than 50% of the employees want to participate in enterprise bargaining. There, of course, will be other options for those people, but it is an exemption which should assist those in small business from being too concerned that they might be roped into an agreement. It's generally intended that small businesses will, where appropriate, access the cooperative workplaces bargaining stream where they want to participate in enterprise bargaining. The cooperative workplaces bargaining stream will allow businesses to voluntarily opt in to be covered by one of the industrial instruments instead of multiple awards. So if you are a small business who is covered by multiple awards, there may well be an enterprise agreement in the future which better suits your needs, but it is really a watch and see in this space. The other change that we've seen that got a lot of uptick in the media was withdrawing from existing enterprise bargaining agreements following the nominal expiry date. Quite frankly, this has always been a difficult task, though not impossible. In recent years, there's been a bit of a perception that some employers have used the capacity to withdraw from an agreement as a weapon in the next round of enterprise bargaining. Although there is little evidence to support that this is happening in any widespread way, there certainly have been some high-profile cases where employers have made such applications to the Commission as part of their negotiation strategy. Even a few have actually been successful. However, To prevent the weaponising in this way, the legislation has made it more difficult to withdraw from an agreement than it was in the past. However, where an agreement has passed the nominal expiry date and there are solid reasons to withdraw from the agreement, such applications can still be made and will be considered on their merits. However, the onus is on the employer in such applications to demonstrate that the withdrawal is genuinely necessary to protect the viability of a business. Because these changes haven't yet been implemented, we don't have all of the information we're going to need. However, we would encourage any employer who's approached by a union to commence bargaining to contact us immediately so that we can work through the specific circumstances, particularly if you're an employer who hasn't been involved in enterprise bargaining in the past and are perhaps a little new to this whole concept of collective bargaining. Next slide, please. Okay, so let's keep going. Fixed term contracts. Now, I know this is another one that a lot of our clients have used for very good reason over many, many years. Importantly, these provisions do not apply until 6 December 2023. It's very rare for employers to do genuine fixed term contracts anymore. The modern version is a maximum or limited term contract. The difference is one of fundamental obligations under the agreement. A fixed term contract guarantees employees employment until a date or an occurrence. And if the contract is terminated prior to that date, the employee is paid for the remainder of the period of the contract. The modern versions, maximum or limited term agreements, do not provide the same protections as they contain notice provisions. So although the agreement has an outer limit, it is not a solid guarantee of employment until that date, and notice of termination can be provided prior to that date. Importantly, although the legislation refers to fixed term, the provisions are actually intended to apply to all of the variations of term arrangements, including the maximum and limited term contracts, which are by far the more usual we see these days. The provisions in the Act are intended to cease the perceived practice that employers are using fixed term contracts to avoid obligations which may arise for permanent employees, such as redundancy. They are also considered to be precarious employment arrangements in that the employee does not have an ongoing guarantee of employment security. From the 6th of December, employers will be restricted from entering into term contracts for more than 2 consecutive periods for the same or similar work, or for more than 2 years. There are some exceptions to this in that there will be some circumstances where term contracts will remain viable. This is where an employee who performs only a distinct and identifiable tasks involving specialist skills. Where there is a training arrangement in place, employees above the high income threshold when they enter the contract, it's currently $158,500. Where wholly or partly government funding work, and there is no reasonable prospect of the funding being renewed. So there it's really important. It's only where the funding comes partly or wholly from the government, and also where there is no reasonable prospect of it being renewed. So if you're a business that operates on recurring government funding, although I know a lot have actually used limited term contracts for the duration of the government funding period, in those cases you're not going to fit within the requirements of the exemptions. The other one is an exemption where some modern awards actually provide for term contracts, and in those cases there will be an exemption for people covered by contracts and who are also covered by those specific modern awards. So it's not the end of the world. You're going to have to look at what you're going to do in the future in terms of, do you fit within any of those exemptions? And if not, how are you going to manage transitioning your workforce from limited or maximum term contracts, or in some cases perhaps even genuine fixed term contracts, onto ongoing contracts, and what that might mean for you in terms of your workforce planning. So, Michael, do we have any questions on the vexed question of fixed term employment contracts?
Look, the questions are coming in fast and furious, okay? I'll try and get through three quickly. First one from Susan. Will that high income threshold change over time?
Thanks, Susan. That's a great question. Yes, it will. The reference is to the high income threshold that's used for other provisions of the Fair Work Act, and it's indexed each year. So that will go up each year.
Good. Now I'll go another one from Petri, and it's on the definition of similar role. So how is similar role defined? Does it depend on subject matter or merely the title, and whether the title is sufficiently and lexically distinct? Is there case law on this?
No, there isn't case law on this because it's all pretty new. I very much doubt it's going to be based on the role title. It will be based on the actual content of the work to be done, and I think that that's why they've used terminology which is a bit broader in terms of the same or similar work. It's intended to get around where people might just tinker around the edges of a role and then say, oh, but it's a different role, so I need a new limited term or fixed term contract. So yes, I think it is going to be about the actual tasks contained in the role.
Okay, I've got another question from Dominic on fixed term contracts. Are shift workers' contracts considered as fixed term engagement?
No, not as such. Dominic, that's a tricky one. You can have shift workers who are engaged on limited term or maximum term or fixed term contracts, or you can have shift workers who are engaged on an ongoing basis. So they are going to fall into exactly the same category as everybody else in terms of fixed term contracts. You won't be able to do fixed term contracts outside of the limitations of the Act for shift workers come 6 December 2023.
Now, Shirley, I'm just going to, because I really like getting these questions, I just want to jump back to the flexible work hours for a second. And Cyan has asked, with flexible work hours, does this apply to all types of contracts, as in awards versus individuals?
Yes, it does.
Okay.
Anyone who falls within that category of employee can make a flexible work request.
Good stuff, thanks. And if you get your questions in as quick as you can, because there's a delay when they come to me, we'll try and get through them. Okay, back to you, Cheryl Ann.
Thank you very much, Michael, and thank you everyone for those insightful questions. I'm really glad this is the last substantive topic I wanted to talk about, and it's zombie agreements. Now, it's not all that important. Can I have the next slide, please? Great, thank you. It's not going to affect all that many people, but I really like the word zombie. And so I like talking about them because I get to say zombie. There are, however, over 100,000 zombie agreements which have been entered into prior to or during 2009. These agreements have long since passed their nominal expiry date, and there are agreements which have not been replaced by a new agreement covered by the specific employer and their employees. Now, look, there might be a whole range of reasons why these are over 100,000 agreements are now being classed as zombie agreements, and not all of them are still have any application or have no application. So there's a whole range of reasons. So, for example, it might be that the employer that was covered by them or the business that was covered by them just simply no longer exists. The business has changed its name and might have an agreement in its new name. The parties wrongly thought that once the agreement had passed its nominal expiry date, it no longer had any application. These are the only ones that I think might be a bit risky, where people think that, oh, once I get past the nominal expiry date, I don't need to refer to it anymore. If those agreements that have past their nominal expiry date still have some application, then that is still lawful to apply that application. So if you've got a zombie agreement, it's worth having a look and seeing whether or not maybe you should have been following some of the terms and conditions in that agreement. The terms of the zombie agreement continue to provide some benefit to employers and employees. So some employers have held on to old agreements because some of the provisions actually provided them with a significant benefit. We see that in some of the hospitality areas. We see it in some of the agricultural areas where the old agreements, because they haven't done new agreements, some of the terms have not kept pace with the awards. So the terms are more beneficial for the employer than if they did a new agreement and had to update for some of the new award terms. If you've got a zombie agreement, such agreements will simply cease to operate from 7 December 2023. So employers who have such agreements don't need to do anything. This will happen as a matter of law. However, if an employer has such an agreement and they continue to rely on it, there is a capacity to make an application to extend the life of that agreement. Such applications need to be made prior to 7 December, and they cannot extend the agreement for more than 4 years. Keep in mind, to extend the agreement, you're going to have to pass the boot test, the better off overall test against current award conditions. So that's going to be a big ask for some of those really old agreements. But if you just happen to be one of these people who's got that agreement hanging around in the background, it's of no use to you, it has no application to you, then do nothing. If you're interested in seeing the list of zombie agreements, then it is on the Fair Work Commission website. It is often difficult to search, and keep in mind that not all employers have entered into agreements under their trading name. They're often under their corporate names. So you may not be able to find some. That's it for zombie agreements. As I say, my favourite part, Michael, was saying the word zombie. And so, do you have any questions for me about the zombies or about anything else for that matter?
Oh, look, no, we've definitely got more questions. We'll probably got time for 2 because I want to finish on time. Not so much about zombies, but it was interesting though because you hear the term being used and going, what are they talking about? So thanks for clarifying that. We've got 2. Maybe a bit more, but we'll try 2. The first one is from Stevie in relation to the fixed term contracts. And Stevie says, does this mean that all fixed term contracts are now required to have an end date?
To be a fixed term contract, it needed to have an end date to start with. So
that's a yes.
Yes, it certainly does. It may well be, and I may have confused you, often people will have an employment contract which is ongoing. Those contracts haven't changed at all. Okay, it's only those where you say, I'll employ you only to a certain date.
Okay, the next question is from Maria in relation to the contracts, and it says, what happens to visa holders?
That is a really good question. If they are here, I would expect filling a very specialist role. They may well get an exemption. They may fall under the first of those exemptions. Other than that, we are going to have to wait and see how that is interpreted by the Fair Work Commission, because there are some limitations, I know, in terms of how long visa holders can work, but at this point in time, there is no specific exemption for visa holders.
Okay, thanks for that. I have actually, we'll squeeze in a zombie agreement question. And the question is from Jim. What is the definition of a zombie agreement?
A zombie agreement is an agreement that was entered into in simple terms, prior to 2009. So it's an agreement under the old legislation, not an agreement under the current Fair Work Act.
Good. We love simple terms to start with anyway.
Yes.
I might ask a question, I don't know if it can be dealt with quickly, and then we'll probably finish. But you did mention how the definition of small business was 20 or less. Is that correct? And
that's correct, Michael, for the purposes of being able to simply decline an invitation to be part of a multi-employer agreement.
Okay, so because there's such significant changes in terms of discrimination, harassment, and all these other areas, is it simple to say, is there a cutoff for small business, or is there an area people can say, I don't have to be worried about this because I've got 3 people or something like that?
No, there are different. The Act provides different definitions of small business for different parts of the Act. No employer gets a free ride in terms of things like general protections, or which will now include sexual harassment and flexible work requests. So they do get, small businesses with less than 15 people do get a greater minimum employment period. They get 12 months. They also do get an exemption from redundancy unless there is something specific in an award. And now less than 20, they're going to be able to say no to multi-employer agreements. But other than that, small businesses are pretty much caught up in the same employer obligations. Now, what might be interesting is when we look at what is all things reasonable, I would expect that what is all things reasonable for the corner store is going to be quite different to what is all things reasonable for BHP.
Okay, that's some relief. See if you can answer one more in 1 minute, okay? It's I'll squeeze this one in if I can. It's from Corrine. It's in relation to terminating maximum term contracts. Are there any changes to the legislation that will impact termination and maximum term contracts?
I can answer that in one word. No.
Excellent.
No change.
Okay, good. All right, hang on. No, I bet. Oh, one more.
Just when I thought it was safe to run away.
No, never safe to. So it's from Sandy. It says, will you be supplying a transcript of the webinar, please? I'm not too sure, Sandy. We'll have someone come back to you on that point. All right, I better stop now, but we will come back to you for people with unanswered questions. Thank you very much, Cheryl-Anne. I think it was, as usual, just an excellent summary so that we can start to digest complex legislation in this field. I know without any doubt, if you're managing employees and you're not aware of the things like the discrimination and harassment obligations that are on the employers and the employees, then you really need to become aware of it. It's impossible to, well, it's not impossible, but it's very inadvisable not to be across all these changes, which is in a way another plug for our May webinar on that topic. But enough for today. Well done, Cheryl-Anne. I thought it was really good and covered the material very well. And to all the participants, thank you very much for joining us. The presentation will be available after the webcast and you'll be able to watch it on demand. So that probably, Sandy, answers your question. And the way to do that is you click on the same link that brought you to this event. So if that doesn't clearly answer those requests for transcripts, send us an email and we'll fix you up. So thank you very much, everybody. Thanks for attending and have a great day.
Thanks, Michael. Thanks, everyone.
See you.